Hello, this is Paul Callaghan. I'm the EMEA Head of Employment, Pensions and Mobility at Taylor Wessing, sitting here in London. And today we're going to be talking about the different leave rules that apply across Europe and which can sometimes be a shock to our North American clients. So the topics we're going to cover include vacation, family and sickness leave, and any other fairly common types of leave that you tend to encounter in the workplace. In Europe, leaves are significantly more extensive than you might be used to in the US and Canada, and there are also certain protections in relation to employees depending on the type of leave they're on. So I'm going to hand over now to my colleague James Watkins, who's going to start off by talking about some of the leaves in the United Kingdom.
Thank you, Paul. So the first topic we're going to cover today is vacation leave in Europe, and we're going to look to deal fairly closely with some of the key questions that were asked day to day of our clients over in America. We're going to look at what might be the statutory minimum legal entitlement for holiday, what we tend to advise to offer in practice, whether or not employees can carry over holiday entitlement from one year to the next, and also how we calculate holiday pay. So a good place to start seems to be the European Working Time Directive, which is a European directive from 1998, which essentially prescribes the minimum amount of holiday that an employee in an EU member state must be able to have, and that is set at 4 weeks. Now, as you'll see as we go through the presentation, this is implemented by national laws in different member states, and a different entitlement can arise in different jurisdictions. Taking the UK first of all, the statutory minimum legal entitlement is 28 days, and that is inclusive of 8 public holidays that we have over here in the UK. However, in practice, and for fairly large employers like yourselves, it would be more common to offer in the region of about 33 days. So those paid vacation days, which you can see on the slide now, would move up to about 25, and you would still have paid public holidays. One of the key questions that we're often asked is whether or not employees can actually carry over holiday entitlement from one year to the next. Now, in the UK, there is actually no legal requirement to allow an employee to carry over their statutory holiday entitlement from one year to the next, unless they've been unable to take that statutory annual leave due to sickness or maternity. However, in practice, it would be common to allow employees to perhaps take 5 days carry over into the next holiday year, perhaps until the end of March, so it gives them a bit of extra time to take that. I'm now going to hand over to Fabian in France, who's going to talk a little bit more about how it works in France.
In France, the legal entitlement to holiday is 25 days, and on public holidays amounts to 11 days. This is a legal minimum which can be enhanced by collective bargaining agreements or employers' decisions. The carryover is not a legal possibility except in certain circumstances. For example, when the employee is in sickness leave and is unable to take his or her holiday, then the carryover is allowed. Holiday entitlement is accrued per month for a number of 2.08 working days per month. And this is how we get to the 25 days per year. As I said, collective bargaining agreements can increase this number. Annual leave is not accrued during sickness state by the employee or during sick leave. Only for non-related work sick leave, because when the sick results from working conditions, then the employee is able to accrue some entitlement to holiday during this period. And this statement is not really compliant with the EU law, but right now French system is not modified, and there is no visibility as it will be. I'm going to pass on to Jonas, who will explain how the German system works.
Thank you, Fabian. In Germany, we have a statutory minimum of entitlement of 20 days per year, which is calculated with a 5 days working week, so 4 weeks in total. But it is absolutely common, and it will be expected by employees that they are granted 25 to 30 days of vacation per year in total, which does not include public holidays. Those are extra. With respect to carryover of vacation entitlements, basically all entitlements forfeit as of the end of the year. However, this is not the case if the employee was not able to take the vacation due to sickness or compelling business reasons, and in such case, the statutory minimum entitlement is carried over for a maximum of 15 months. However, this is only the case if the employee was sick throughout the whole period of 15 months. And the extra vacation, which is granted by employers, is carried over for 3 months, so to end of March of the next year. What we are often asked is whether it is possible to pay the employees instead of granting vacation, and this is only possible if the vacation cannot be taken due to the end of the employment contract, so it's not possible for any other reasons, and it would be a breach of law. With respect to accrual of annual leave whilst on sick leave, it does accrue. However, the basic rule under German law is anyhow that the full yearly entitlement accrues as of the beginning of each year, so this is not really an important question. I will hand over to Rosalina.
Thank you. The Dutch system is more or less the same as the German system. In the Netherlands, employees are entitled to a statutory minimum of 20 days. However, the market standard is 25 days holiday or sometimes even 30. In addition, employees are entitled to 9 public holidays. Employees have to take the accrued but untaken statutory holidays within 6 months after the end of the calendar year in which they have accrued. Otherwise, they will in principle lapse. This 6 months limitation period will, however, not apply if an employee has not had a reasonable opportunity to take the statutory vacation. The 6 months only applies to statutory vacation days and will not apply to additional vacation days on top of the 20 days. Employers can pay the employees the annual leave entitlements on termination, and also with respect to the additional vacation days, but not with respect to the statutory vacation days. Employees are also entitled to the accrual of holidays while they are on sick leave. Agreed days of holiday exceeding the statutory minimum are to be fully accrued during illness as well. Exceptions are, however, possible in a collective labor agreement or by mutual agreement between employer and employee. I will now hand over to Brigitte in Austria.
So, in Austria, statutory holidays amount to 25 days plus 13 paid public holidays. After a longer period of service, the statutory amount increases to 13 days. However, the market standard does usually not exceed the statutory entitlement of 25 days or 30 days after a certain amount of service. In CEE, it amounts to about 20 days. The entitlement may be carried over for 2 years in Austria. In CEE, it differs. On termination, and only on termination, the employee has a right to claim compensation for leave that has not yet been taken in Austria and CEE. Annual leave also accrues during sick leave, and like in Germany, it is the fact that the holidays actually accrue at the beginning of the year in total, so the 25 or 30 days. So that was for Austria and CE, and I hand over to James. Hello, James?
Thank you, Brigitte. Thank you. So I think an overriding theme we can pick out there is that the vacation leave entitlement throughout Europe is somewhat more generous than you might be used to over with you. I thought one thing that we could quickly focus on as well, and it may be something that has been brought to your attention, particularly for those of you who have employees who probably less so do overtime, but that do earn commission whilst they work, is some recent European case law in the last few months that really has brought into focus what should be included in the calculation of statutory holiday pay. Now, at the moment, and it had been for a while until this case law, from the UK perspective, that an employee's statutory holiday pay would be calculated based on their basic salary only. There was a case that went through the court where this was tested, and basically the result of this is now that anything which is intrinsically linked to an employee's salary, so any commission they earn, any overtime they do, that should also be included in the calculation of the holiday pay. And I thought, therefore, it would be useful just to have a quick canter through the other jurisdictions in Europe and to see what the position was there, as this will be particularly relevant for those employees that do earn commission. So I thought I would start with Fabien in Paris, first of all.
Fabien, let's make sure you're not muted on your phone.
I'm sorry, I was muting. Yes, thank you very much. Sorry for that. Under French law, we have a two-option system. The employer can either take the same salary that the employee usually earns per month, or if more favorable, it can take over the last 12 months the whole remuneration earned by the employee, which means base salary, bonus, overtime payments, and so on, and divide this annual, or multiply, this annual remuneration by 10%, and this 10% will be the base reference salary that will be used to pay the employee during his vacation. So it's the most favorable that will apply to the employee. I'll pass on Jonas for Germany.
All right, thanks, Fabian. In Germany, even before this current recent European case law decisions, the situation has been that an employee has to be treated as if he or she had worked during the vacation, and for that, employers have to look into the last 13 weeks prior to the vacation and pay all salary components which were paid during this time. The only aspect that is not taken into account is overtime, so there is no overtime pay during vacation, but anything else, so bonus and commission and further variable pay is all taken into account. What's the situation like in the Netherlands?
It's not entirely correct in the slides. Consequently, shift work allowance and agreed benefits are considered part of the agreed wage and therefore are part of the holiday pay. Overtime can also be part of the calculation of holiday pay, but only under specific circumstances. So basically, employees are entitled to the same salary as if they had been working. And what's it like in Austria, Brigitte?
Yeah, Rosalie. In Austria, in general, the employee is entitled to the salary he would have earned if he had not taken the holidays. So actually the base salary has to be considered, as well as the bonus and any commission. Overtime has to be considered only if the employee regularly works overtime. So this has to be looked at the average of the last 13 weeks or sometimes more, so that then this has to be considered. What is actually interesting in Austria. It's a peculiarity in Austria, but not in CEE, is the extra monthly salary per year for holidays. So it's called the 13th salary, such as also the 14th monthly salary for Christmas, for example, which both are provided usually in the CBAs. Yeah, that was for Austria and CE, and I pass on to James.
Thank you, Brigitte. So now, having taken a quick look at vacation leave, we thought we would move on to some of the key family leave rights, and again we'll start with the UK. Starting with maternity leave in the UK, a female employee is entitled to 52 weeks statutory maternity leave and statutory maternity pay of 90% of the average weekly earnings for the first 6 weeks, and then for the next 33 weeks, the lesser of the current statutory rate, which is £139.58, and 90% of the average weekly earnings. The earliest point maternity leave can be taken, which is a question we're often asked, is 11 weeks before the expected week of the childbirth. Moving on to paternity leave in the UK, the statutory right is for 2 weeks, and the statutory paternity pay rate is the same as maternity statutory rate, and again it will be the lesser of 139.58 and 90% of the average weekly earnings. This leave will usually be taken, or will be taken in the 2 weeks after the baby is born. That's the statutory position, but often large employers will decide to offer an enhanced entitlement, particularly to maternity pay, and it might be that they decide to offer a month or 2 months above the statutory amount, so that could be full pay, and then perhaps a month of half pay, and then for however many weeks are left, up to 39 weeks, the statutory rate would continue from there, and that is quite a common thing and seen as a good benefit for large employers to offer. One of the key things we advise on day to day is also the protection of employment rights during maternity leave. And the statutory position here is that female employees have the right to return to the same job on the same terms and conditions as if they hadn't been absent during the first 26 weeks of maternity leave. This right, in fact, still applies during the second 26 weeks, unless it isn't reasonably practicable, in which case the employee must be offered a similar job on terms and conditions which are no less favourable to those that they had before. Now, maternity leave and return to work and redundancy situations are fraught with various discrimination issues, and if you ever encounter yourselves in one of these, we would advise you to take advice. One of the key legislative changes in recent times in the UK, in fact in the last couple of months, has been the introduction of a new flexible shared parental leave system. Essentially what this means is that after a female employee has taken 2 weeks of their compulsory maternity leave, so that they must take that, they are entitled to share the next 50 weeks with their partner. At the moment, the uptake hasn't been that high. And there's been a few questions that have been asked of it. There are various notification and eligibility requirements, and one thing we're doing at the moment is putting together policies for employers over here in the UK to deal with this, to give their employees an awareness of the rights and to let them know what they need to do in order to request it. One further area that we thought would be useful to mention is unpaid parental leave. So this is completely different to anything I've spoken about so far, very different to shared parental leave. And basically what this means is that a parent of a child is entitled to take 18 weeks of unpaid leave up until a child is 18 years old. So that's the basic situation in the UK, and I'm now going to hand over to Fabien in France to talk about the French system.
Thank you, James. In France, the statutory maternity leave amounts to 16 weeks, usually or legally divided in 6 weeks prior to the birth and 10 weeks after, but it is often and very usually amended between the employer and the employee, who can decide to have the division of the period modified. The 16 weeks period is enhanced to 20 weeks period when the employee is expecting a third child, and to 34 weeks when the employee is expecting twins, and up to 46 weeks when the employee is expecting triplets. Of course, collective bargaining agreements can grant additional periods, which is often the time, especially in third sector branches, as banks, for example. Employees receive a maternity pay during the whole maternity leave, which takes the form of a daily allowance served by the Social Security, and which is equivalent to approximately not 80% as mentioned in the slide, but 50%. This is a minimum provided by law, and in most of the companies, even small or large companies, employers, through their healthcare coverage and maternity coverage, get the salary of the employee to a full salary, i.e. 100% salary during the whole leave. Upon return from the maternity leave, the employee must be reinstated into her former position. As in the UK, she cannot suffer any loss in her salary and benefits, and she must be treated as she had never left from office during the leave. Of course, employees cannot be listed for being pregnant or on maternity leave, and this protection of pregnant employee starts from the day that she informs the employer that she's pregnant up to the 4th week after her return from maternity leave. Two exceptions to that: the employer might decide to dismiss the employee for gross misconduct, but he has to prove that the misconduct does not result from the pregnancy condition of the employee, or that he is unable to maintain the employment of the employee, which is very complicated to evidence and which is very rarely used as a ground for dismissal. As regards paternity leave, it exists in France for 11 days in a row, which can be increased to 18 days when the partner expects multiple births. The leave has to be taken within 4 months after the birth. And as for maternity pay, paternity pay takes the form of daily allowance served by the Social Security regime, and is equivalent, as for the maternity system, to 50% and not 80% of the remuneration. And here again, through the health coverage of the employer, the employee can reach a full salary during this period. Contrary to the UK system, there is no parental leave, the shared parental leave system in France. And as for the UK, French law provides for a parental leave, which can take either the form of a full leave, during which the employee will not be there, up to 3 years after the birth of the child, or a part-time work organization, as long as the whole system is agreed on between the employer and the employee. I will hand out to Jonas for the German system.
Thank you, Fabien. In Germany, we have a statutory maternity leave of 14 weeks, which is 6 weeks prior to giving birth and 8 weeks after giving birth. There is no pay during maternity leave. However, the mother receives an allowance which is financed by statutory Social Security system, so it's also not common to offer any pay during this time because they receive a full compensation. We do not really have a paternity leave. It is common to grant 1 day off with pay on the day of birth, and what fathers can do is take parental leave. So we have a system of shared parental leave, and parents can take the parental leave up to the 3rd birthday of the child. And just recently, they are allowed to move 24 months of those 36 months up to the 8th birthday of the child. And also during parental leave, there is no pay. but for up to 14 months if they share the parental leave, the parents are being paid 67% of their salary, up to a maximum of 1,800 euros per month. This is also paid by Social Security, and it's also not common to offer anything further. What parents sometimes do, they are allowed to work part-time doing such leave for up to 30 hours per week. So they have the possibility to earn more. During any of those leaves, the parents are protected against dismissal. This means a dismissal is not possible unless the competent authority has given its consent. And yes, that's pretty much about it. So what's the situation like in the Netherlands, Rosalie?
Thank you, Jonas. Well, in the Netherlands, the statutory maternity leave is 16 weeks. Pregnancy leave must commence at least 4 weeks and up to 6 weeks before the expected date of delivery, and the remaining time can be taken after the birth of the baby. If the baby was born later than the expected delivery date, the leave could be extended to at least full 10 weeks paid leave. And during the maternity leave, female employees receive a benefit equal to 100% of their normal earnings, up to a maximum of the maximum daily wage of 199 euros per day at this moment. And this is paid by the Social Security system to the employer, but usually the employers pay the full salary to the employee. Women who have to leave work earlier in their pregnancy for medical reasons are also entitled to 100% of their normal earnings when they are not working. Women who are unable to return to work after birth for pregnancy-related medical reasons can also receive 100% of their income for up to 2 years, which is also paid by Social Security. While pregnant, women have a wide range of workplace-related rights. In applying for a job, for example, they're not required to notify the prospective employers of their pregnancy. They cannot be turned down for a job because they are pregnant. Employees can, of course, not be dismissed while pregnant or within 3 months after giving birth. There is also no obligation on the female employee to work overtime or on night shifts up until 6 months after the birth of their child. Well, fathers also have some rights, but not many. Fathers have the right to paid paternity leave to attend the birth of their child, and for 2 days leave, which can be taken at any time within the following 4 weeks. In addition, they are also entitled to 3 days of unpaid leave. Both mothers and fathers who have worked for their current employer for at least a year are entitled to take a specified amount of unpaid parental leave to care for each of their children up to a maximum of 26 times the weekly working hours of a year at any time during the first 8 years of the child's life. The amount of leave that can be taken depends on the number of hours usually worked and can usually be taken as up to 50% of the normal working hours per week. Well, that's the basic situation in the Netherlands. How is it in Austria, Brigitte? Brigitte?
Oh, hi.
Yes.
Oh, thanks, Rosalie. Yeah, in Austria, female employees are not allowed to work 8 weeks before and 8 weeks after birth. It's called maternity protection leave. The pay amounts to the average income earned during the last 13 weeks, and it is provided by the social insurance carrier. Thereafter, after the 8 weeks after birth, maternity or paternity leave may be chosen between 2 months and 2 years. The minimum is 2 months. from the end of the 8 weeks maternity protection leave. Parental pay during this time is also paid for by the social insurance carrier. Mother or father can claim parental pay for up to 36 months. However, the longer the payment period, the lower the pay. You see here the examples. There are 5 possibilities that can be chosen with different duration and different amounts of pay. Special dismissal protection exists in favor of the mother or the father, depending on who is on leave, until the 4th, and to a limited extent, until the 7th birthday of the child. Dismissal can only be declared if judicial approval is given. Female and male employees are entitled to return to work in the same position and on the same salary. There is further entitlement to part-time work after the maternity leave, maternity or paternity leave. It's also for mother or father. It can be therefore shared, but not at the same time. And it can go until the 7th birthday of the child. The employee can request such a part-time, and the employer may oppose, but it can be decided by the court. Dismissal protection is therefore also granted in this period, as I said, until the 7th birthday. In CE, leave time varies, but payment is mostly provided by the state, and dismissal protection also exists. Yeah, this was the position in Austria and the CE, and I pass on to James.
Thanks, Brigitte. So hopefully some of the generosity of the European leave rights hasn't left you feeling too sick, but it's probably a good time to move on to sick leave rights in Europe, and again we will start with the UK. So what are the key sickness absence issues over here in the UK? So what do you need to do when an employee goes off sick? How much do you need to pay them? Do you pay an enhanced amount, and how long can they be off? Those kind of things are what we're frequently asked. So I think the starting point is that employers must be given a sick note if employees are off for more than 7 days in a row over here in the UK. There's no legal requirement for an employee to be paid during the first 3 days that they're off sick, but from the 4th day that they're off on sick leave, they will be paid statutory sick pay, which will always be at the current statutory rate, which at the moment is £88.45. It will last statutory sick pay for 28 weeks. However, many large employers, similar to what they do with maternity pay, decide to offer some contractual sick pay. So particularly for those senior employees or very valuable employees, it's seen as quite a good benefit to offer them maybe a couple of months of contractual sick pay, which would be their normal pay, then perhaps give them half a month's pay before resorting back to the statutory rate. But you really do have discretion as an employer there to decide what you want to offer. I think one thing that we see regularly frequently is that it's important to ensure that all your contracts and your policies do tally up with what you do in practice. So, for example, if you don't have an express clause in your contract or your handbook about contractual sick pay, but there's a practice of paying sick pay, then you need to make sure that you are consistent when you do that with other employees across the workforces. It may be that they could come and argue that there is an implied contractual right to sick pay through others having been paid that in the past. So I think one of the key things to mention in relation to sickness and particularly the management of sickness absence in the workplace is to have clear policies in place that manage the sickness absence and also any unauthorised absence. And this is particularly the case in relation to long-term sickness absence. And I guess if you could take away a few things when dealing with employees that are on long-term sick is as an employee, really need to get to the bottom of what the nature of their condition is, particularly if they might be afforded protection under the Equality Act over here in the UK. We'd be looking at things whether or not you need to make reasonable adjustments for them, and in a termination situation whether there might be any alternatives to dismissal. For those employees that are offered permanent health insurance or disability insurance, it's again an area which is fraught with issues. If you're looking to get rid of an employee who has PHI benefit, if you don't have, for example, an express clause in your employment contract which would enable you to terminate that employee, notwithstanding the effect that this would have, that would then be losing their PHI benefits. So there are a number of things to consider, and I appreciate that's a very high-level overview, but I think it's something that really should be documented in policies. So now I'm going to hand over to Fabian once again to give an idea on the French position.
Thanks, James. The key question under French law is that, well, the key requirement under French law is that the employee informs both the Social Security Administration and his or her employer of his sick leave or his sickness, so that first of all he would be covered by the Social Security regime to get paid during the sick leave, and so that he will not be considered as being absent without any justification by his employer. The entitlement to be paid during sick leave is subject to a 1-year service with the employer, and to provide, as I said, a medical certificate within the 48 hours of the illness, both to the employer and to the Social Security, so that he can be or she can be covered by the Social Security Administration. But having said that, it has to be noted that under French law, the employee will be covered by the Social Security allowances for sickness only after the from the first day of sick leave, which means that during the first 3 days of sick, he or she will get nothing, either from the Social Security or from the employer. After the 3 days, the common regime is that the employee receives during the first 30 days of sick leave remuneration amounting approximately to 90% of his standard remuneration. And during the following 30 days of sick leave, he or she will receive 2/3 remuneration of his standard salary. Collective bargaining agreements can increase this coverage, but it's quite rare given the fact that this regime is already quite advantageous for the employees in France. The daily indemnity from the Social Security system for employees can go on during a maximum duration of 3 years, even though the complementary remuneration from the employer will not cover the employee for more than 60 days. But the Social Security regime can go on during 3 years. As regards the termination based on ill condition, well, of course, dismissing an employee based on health condition would be considered as discriminatory, and then the termination will be null and void, which means that not only the termination will be considered as unfair, but the employee would have to be reinstated in his prior employment with back wages as from the date of his or her dismissal. Having said that, 2 exceptions exist under French law. The first one is that when the employer is suffering a repeated or long absence of his employee because of his sickness, and if the employer can prove that this absence has a detrimental impact on the organization of his company, and that he needs to replace the sick employee on a permanent position, which is only through an open-ended contract and not only a fixed-term employment agreement, then he might be able to dismiss the employee. But this situation is very risky under French law because of the conjunction of the 2 conditions, or 3 conditions. One, the longer of the absence is long enough. 2, that it is detrimental, and 3, it has to be replaced by another employee. So this is very often met case, but very risky for employers. And on top of that, collective bargaining agreements can provide for a period of guarantee of employment when the employee is under sick leave, which means that it can range from 6 to 12 months, during which the collective bargaining agreement will provide that the employee cannot be dismissed during his sickness, even though the employer is facing detrimental impact because of the absence of his employee. The second exception to the prohibition to dismiss is when the employee is declared by the doctor of the company unable to be reinstated in his former position. When the doctor provides this medical advice, the employer should only be authorized to dismiss the employee if he cannot find any alternate position in the company or the group, if the company belongs to a group of the employee. So this is not only because the the doctor will say that the employee cannot work anymore at his former position that the employer will be able to dismiss. He will have to make his best to find another position, and only if no alternative position can be found, the employee can be dismissed. And if such redeployment endeavor is not complied with, then the dismissal will be considered as unfair.
Thank you, Fabian. Perhaps now, Jonas, you could give a very quick overview in the interest of time of the position in Germany.
All right, sure. I will. So the basic sick leave in Germany is 6 weeks, and this is not per year but per illness. This sometimes causes confusion. This means that for a period for up to 6 weeks, the employee is entitled to full pay for each kind of sickness. And in fact, if the employee is back at work and becomes sick again with because of another sickness, he or she is again entitled to full pay for 6 weeks. And also a very common problem we face is that we do not know the reason why the employee is out sick, so we don't know the type of sickness. After the 6 weeks expired, there is no further pay, but the employee receives an allowance which amounts to approximately 60% of the employee's pay, and which is paid by their healthcare insurance. There is it is possible to dismiss employees during sick leave, so there is no limitation on that, and it is also possible to dismiss employees based on long-term sickness. However, it's not possible, but a thorough investigation is needed and a forecast that substantial times of absence will also occur in the future, and that this will have a substantial impact on the employer, which exposes the employer to such negative consequences that it cannot be reasonably expected anymore to continue this employment. Well, this really in a nutshell the basic situation in Germany. So I'm passing on to Rosalie.
Thank you, Jonas. Well, in the Netherlands, if the employee becomes ill, the employer is required to pay at least 70% of the wage last earned by this employee for a maximum of 2 years. The wage is linked to the maximum daily wage, which again is 199 euros per day. The employer is obliged to supplement this amount to at least the minimum wage during the first year of illness. The statutory minimum wage guarantee does not apply to the second year of illness of the employee that's, of course, on long-term sickness leave. The 2-year period can be extended by 1 year if the employer did not do enough to reintegrate the employee, and therefore the employer must work together with the employee to do all he can to ensure that the employee resumes work as soon as possible. And as you can see, Dutch law obliges the employer to take a number of steps specifically with respect to employees that are on a long-term sickness within a certain period of time. And the employer and the employee have to draw up a plan of action. They have to maintain a reintegration file, which records all activities and correspondence with the company doctor, and therefore we recommend to make clear policies to manage sickness absence. The employer has the option to temporarily discontinue payment of wages if the employee does not cooperate sufficiently with respect to resuming his work. Insufficient cooperation of the employee can even serve as a ground for dismissal. After 2 years of illness, the employee may be eligible for a benefit paid by the government if, of course, the employee is still ill. The contract of employment can also be terminated after the 2-year period by the employer. Before the contract can be terminated, however, the unemployment office in the Netherlands, which is a governmental office, has to assess whether or not the employee could in any way resume work within a certain time frame, and if both parties did enough to avoid a benefits claim, and otherwise you have the extra year of payment of the employee. So long-term sickness is not good for the employers in the Netherlands. How is it in Austria, Brigitte?
Thanks, Rosalie. In Austria, sickness has to be notified by the employee, and a medical certificate has to be provided by the employee at the request of the employer. If the employee fails to do so, the employer is entitled to withhold the salary for that time. There is an entitlement of the employee to time off paid by the employer between 6 and 12 weeks, and thereafter to half pay for 4 weeks. After that, the state provides for sick pay. The employer can partly recover sick pay from the social insurance carrier of up to 58% of the sick pay it has given to the employees. Not common is to pay an enhanced sick pay. Only senior executives are sometimes granted enhanced sick pay by the employer. The employer is also allowed to terminate employment during sickness absence. However, if sickness exceeds the end of the employment, the employer must continue payment for the periods mentioned above and prescribed by law. If disability is established, the employee enjoys increased protection. A termination would in this case only be valid after approval of the disability committee. In CE, the employee is also entitled to sick pay, and there it's partially paid by employer and partially by the state, but this varies from land to land. This was for Austria and CE, and I pass on to James.
Thank you, Brigitte. So we've obviously covered quite a bit of ground so far today in the various forms of leave, and it's probably right to also bring to your attention that there are other forms of leave, for example, bereavement leave and time off work from your employer for public duties. I thought I would just quickly summarise how this works from the UK and across Europe. Basically, there is an entitlement of a few days, it would seem, across the various jurisdictions for death of a spouse or children or things like that. And I think it's probably one of those areas as an employer where you really would look to exercise your discretion and deal with it on a case-by-case basis. As I said, also there's right to time off for public duties, and the employee must be granted in the various jurisdictions where this right is available, the opportunity to do so. More details of these other forms of leave will of course be provided in the slides that we circulate tomorrow. So just to sum up, I think some of the key things we need to look at in relation to leave rights is to get in place good, robust policies and to make sure that what we do in practice mirrors what is in the policies. I think this then avoids any issues further down the line. Areas that are particularly fraught with issues could be terminations in relation to sickness absence, and any potential dismissal of employees when they return from, for example, maternity leave. And those are probably a couple of the key things to focus on from today. So I'm now going to hand over to Paul Callaghan, the head of the Employment and Pensions Department here in the UK, who will sum up.
Yeah, so thanks for that. I hope you found that useful. There are detailed slides which we are going to send out tomorrow, but if anybody does have any questions, do feel free to email them through. All of the speakers' email details are at the back of the slide pack, which you will get, as I say, tomorrow. We've run out of time, so we can't take any more questions now. I hope you'll join us for our next webinar in our EMEA General Counsel series, which is going to be on Thursday, August the 6th. And that's to talk about data privacy issues in Europe, in particular in the workplace, and how to deal with background checks and the processing of personal data relating to your employees. So thank you again for joining, and I look forward to welcoming you to our next webinar. Thank you.
Thank you very much for joining our webinar today. You may now disconnect your line.